The moving truck pulled away from our driveway on a perfect spring morning. Sunlight filtered through the trees lining Oak Ridge Boulevard, casting dappled shadows across what was now our front yard. Sarah, my wife, stood beside me, her hand intertwined with mine. "We did it," she whispered. Our daughter Emma sat in her wheelchair on our new concrete driveway, her eyes bright with excitement as she surveyed our new home. We had searched for nearly a year to find the perfect house. Emma was born with spinal muscular atrophy, a genetic disorder that affected her muscle strength and movement. Finding a home that could accommodate her needs while still feeling like a real home had been challenging. But Sunnydale Estates seemed to offer everything we had dreamed of: good schools, friendly neighbors, and a house with enough space on the ground floor for Emma to move around comfortably. The neighborhood itself looked like something from a movie. Manicured lawns stretched in every direction. Children rode bicycles along the sidewalks. Neighbors waved from porches. During our house hunting visits, we had noticed how clean and well-maintained everything appeared. The homeowners association clearly took pride in the community aesthetics. At the time, I considered this a positive sign. "The Johnson family has arrived," a cheerful voice called out. Our next-door neighbor Diane approached, carrying a homemade lasagna. "Welcome to Sunnydale Estates. We are so happy to have new neighbors." Her genuine warmth made us feel immediately welcome. Within the first week, several other neighbors came by with baked goods, plants, and invitations to backyard barbecues. Emma was especially excited about meeting other kids her age. Our first real introduction to the community came at the monthly neighborhood gathering in the communal park. Residents brought potluck dishes and mingled under string lights. Sarah pushed Emma's wheelchair across the grass, and I carried folding chairs. People smiled and introduced themselves. Emma laughed with a group of teenagers who invited her to join their table. "You must be the new family on Oak Ridge." A woman in a crisp white blouse and pearls approached us. Her smile appeared practiced, not reaching her eyes. "I am Patricia Thompson, president of the Sunnydale Estates Homeowners Association." She extended a manicured hand. "We are very particular about maintaining our property values here. I am sure you understand how important that is." Her gaze lingered on Emma's wheelchair for a moment too long. A flicker of something, disapproval perhaps, crossed her face before her smile returned. "We have very specific guidelines about external modifications to homes. Make sure you consult the HOA handbook before making any changes." With that, she glided away to greet another family. Later that evening, Sarah mentioned the interaction. "Did you notice how she looked at Emma's chair? Something felt off." I dismissed her concerns, attributing them to new home jitters. "Everyone else has been wonderful. Let us focus on settling in." Emma's medical condition required regular physical therapy and doctor appointments, but her spirit remained unbreakable. She had inherited Sarah's artistic talent and my stubborn determination. Despite the challenges she faced, Emma approached life with remarkable resilience and humor. Her bedroom walls soon filled with her artwork, colorful landscapes and portraits that revealed how she saw the world. As we fell into a comfortable routine, I felt genuine optimism about our new beginning. The neighborhood seemed ideal. Emma was adapting well to her new school. Sarah had started working from home as a graphic designer, and I had a manageable commute to my job as an architectural engineer. Sunnydale Estates was everything we had hoped for: a fresh start for our family, and a place where Emma could thrive despite her physical limitations. I had no idea that our peaceful beginning was about to collide with an unexpected storm. 6 weeks after moving in, we decided it was time to address the front entrance. Emma had been managing with our temporary solution, a portable aluminum ramp that we deployed whenever she needed to enter or exit. But the setup was cumbersome and required assistance each time. As an architectural engineer, I knew we could design something both functional and aesthetically pleasing that would blend with the colonial style of our home. I spent evenings drafting plans for a gently sloping concrete ramp with brick facing to match our exterior. The design included tasteful railings and even incorporated planters to enhance the overall appearance. Once satisfied with the plans, I submitted them to the HOA Architectural Review Committee, along with the required forms and fee. 2 weeks passed without response. Emma continued to struggle with the temporary ramp, which became especially difficult during a rainy period. Finally, an official-looking envelope arrived in our mailbox. Sarah, Emma, and I were eating dinner when I opened it and began reading aloud. Dear Mr. Mitchell, the Sunnydale Estates Architectural Review Committee has reviewed your application for external modifications and finds the proposed wheelchair ramp to be inconsistent with neighborhood aesthetic standards. Your application is hereby denied. All external modifications must preserve the architectural integrity of the community. Please refer to HOA Guidelines Section 4.3 regarding appropriate exterior features. My hand trembled as I lowered the letter. Sarah looked stunned. They cannot do that, can they? This is not some garden gnome collection. Emma needs this for basic access to our home. Emma stared at her plate, pushing food around with her fork. It is okay, Dad. I can keep using the portable one. The resignation in her voice broke my heart. She was 14 years old and already accustomed to accommodating others rather than being accommodated. The next morning, I called the HOA office and requested an appointment with Patricia Thompson. The receptionist sounded hesitant but scheduled me for that afternoon. When I arrived, Patricia kept me waiting for 20 minutes before inviting me into her office, a space decorated with photos of pristine homes that had won the Yard of the Month award. Mr. Mitchell, while I understand your situation, our committee decision is final, she stated before I could fully explain. That ramp would be visible from the street and dramatically alter the appearance of your home. My daughter needs this for basic access, I replied, working to keep my voice steady. We designed it to complement the house aesthetically. It is not just a functional necessity but a matter of dignity. Patricia leaned back in her chair. Perhaps you should consider using the back door instead. That would be much less visible to the neighborhood. Or maybe your family would be better suited to a more accommodating community. Her suggestion landed like a slap across my face. On the drive home, my initial shock transformed into determination. That evening, I walked the neighborhood with my camera, documenting every external modification I could find. Basketball hoops bolted to driveways, elaborate garden structures, decorative water features, and most significantly, at 47 Maple Street, 3 blocks over, a wheelchair ramp leading to the front door of the Henderson family home. The next day, I returned to the Henderson house and introduced myself to Bill Henderson, whose elderly mother had moved in with them last year. Oh, the ramp. No problem at all with the HOA. Patricia fast-tracked the approval herself. Her mother and mine were friends in the garden club. Over the following weeks, I discovered more inconsistencies. Houses with unapproved pergolas received no violations. Families friendly with Patricia installed backyard structures without permits. Meanwhile, homes belonging to residents who had previously challenged the HOA received citations for minor infractions. I began keeping detailed records, photographs, dates, and notes from conversations with neighbors. A pattern emerged that went beyond bureaucratic rigidity. This was selective enforcement based on personal preference. And somehow, our family, specifically Emma, had landed on the wrong side of Patricia's favor. The realization dawned gradually but unmistakably. This was not an isolated incident, but a pattern of behavior targeting our family. The denial of the wheelchair ramp was not about aesthetics or property values. It was about something far more disturbing: discrimination against my daughter because of her disability. As this understanding solidified, so did my resolve to fight back. What began as a simple request for accommodation had transformed into something much larger: a battle for equality, dignity, and justice. The conflict escalated with alarming speed. 1 month after our ramp denial, official HOA violation notices began appearing in our mailbox with disturbing regularity. The first claimed our garbage cans remained visible from the street 4 hours after collection, a violation of Section 2.1 of the Community Guidelines. The second cited our grass as exceeding the maximum allowable height of 3 inches. It measured 3¼ inches according to the attached photographs. The third complained about holiday decorations, left up 1 day beyond the permitted time frame. Each violation carried a warning and potential fine. While none individually seemed catastrophic, the pattern was unmistakable. Our neighbors confirmed they had received no such notices despite similar or worse infractions. Patricia Thompson had clearly placed our home under special scrutiny. The neighborhood dynamic shifted subtly but noticeably. Some neighbors began avoiding us, crossing the street when they saw us approaching, or suddenly becoming busy when we waved. Others offered quiet support. Diane from next door brought coffee one morning and spoke in hushed tones. "Patricia is on the warpath about your family," she confided. "At Bridge Club last week, she mentioned how certain elements could bring down property values. Everyone knew she meant Emma's wheelchair. Most of us think it is horrible, but people are afraid of becoming her next target." The invisible battle lines divided the community. Families with children who played with Emma continued to invite her for playdates and activities. Others, particularly those with close ties to Patricia, suddenly had no time for us. Sarah began to withdraw, hurt by the subtle ostracism. I grew increasingly angry but tried to shield Emma from the worst of it. Then came the incident at the community pool. Emma had been invited to a weekend swim party with several neighborhood teens. Sarah and I were relieved to see her enjoying normal teenage social activities despite her physical limitations. Emma had a waterproof chair for swimming pools, and the other kids had always been supportive and inclusive. I was working in the yard when Sarah's car screeched into the driveway. Emma sat in the passenger seat, her face streaked with tears. Sarah looked furious. "Patricia's son and his friends were at the pool," Emma explained between sobs. "They started imitating the way I move my arms. They called me Robot Girl and asked if I was going to short-circuit in the water." The mockery had continued until Emma asked to come home early, humiliated in front of her new friends. That evening, we received an email notification about an emergency HOA meeting regarding community standards and property values. The attached agenda included a segment titled "External Modifications and Aesthetic Consistency." The meaning was clear: Patricia was escalating her campaign. The meeting took place in the community clubhouse. Nearly every household sent a representative, an unusual turnout for a weeknight. Patricia stood before a projected slideshow of neighborhood violations. I noticed that 7 of the 12 slides featured our home, with several showing Emma's portable ramp or her adaptive equipment temporarily left on the porch. "As you can see," Patricia continued, clicking through images, "inconsistent adherence to our guidelines threatens the aesthetic integrity of Sunnydale Estates. Studies show property values can decrease by up to 15% when architectural cohesion is compromised." After the meeting, a neighbor named Robert approached me. He served on the HOA board but often remained quiet during discussions. "You should know something," he whispered. "Patricia has been posting about your situation online. Not by name, but anyone who knows the situation would recognize it. Some of the comments are concerning." That night I found Patricia's social media accounts. What I discovered made my blood run cold. In a private community group, she had posted thinly veiled references to our family, complaining about special treatment demands and playing the disability card. Worse, she had shared memes mocking people with physical disabilities. Several comments expressed support for maintaining standards and preventing these people from taking advantage. The next morning, I contacted a disability rights advocate recommended by Emma's doctor. Jennifer Lawson listened carefully to our situation, taking detailed notes and occasionally shaking her head in disbelief. "What they are doing is not just morally wrong, it is illegal," she explained. "The Fair Housing Act explicitly prohibits discrimination based on disability, including refusing reasonable modifications necessary for equal use and enjoyment of the property. A wheelchair ramp is textbook reasonable accommodation." Jennifer explained our rights under federal law and outlined potential actions we could take. She provided documentation about similar cases and outcomes. For the first time in months, I felt a sense of direction and hope. That evening, our kitchen table transformed into a war room. Sarah, Emma, and I spread out papers, laws, and strategies. We were no longer confused victims, but informed advocates prepared to fight for justice. Emma's expression shifted from resignation to determination as she reviewed the Fair Housing Act provisions. "We are not asking for special treatment," she said firmly. "We are asking for equal access, and we are going to get it." As we organized documents and evidence, I realized our battle had evolved from a simple request for a wheelchair ramp into something much larger, a stand against discrimination, and a fight for our daughter's dignity and rights. Patricia Thompson had underestimated our resolve. She had picked a fight with the wrong family. And we were now prepared to use every legal tool available to establish not just our right to modify our home, but our right to be treated with basic human dignity and respect. The following week marked a turning point in our approach. No longer reactive, we implemented a comprehensive strategy with multiple components. First, we submitted a formal request for reasonable accommodation under the Fair Housing Act, mailing copies to both the HOA board and Patricia Thompson personally. The letter, drafted with Jennifer's assistance, cited relevant laws and precedents while documenting the pattern of discrimination. "Keep copies of everything," Jennifer advised. "Document every interaction, every email, every phone call. Create a paper trail that cannot be ignored or denied." We purchased a dedicated notebook for this purpose. Each entry included dates, times, participants, and verbatim quotations when possible. What began as a few pages quickly grew into a substantial record of our interactions with the HOA and Patricia specifically. Emma contributed to our documentation efforts. Her artistic abilities proved useful as she created detailed sketches of our proposed ramp design, demonstrating how it would blend with the architectural style of our home. These drawings contradicted Patricia's claims about aesthetic inconsistency. Meanwhile, Sarah initiated quiet conversations with sympathetic neighbors. "We are not asking anyone to take sides publicly," she explained during coffee with Diane. "We just want people to understand what is happening and why this matters to our family." These private discussions expanded our coalition of support. Robert, the quieter HOA board member, began providing us with information about board discussions and Patricia's behind-the-scenes maneuvers. She has been pushing to modify the HOA guidelines to specifically prohibit ramps visible from the street, he revealed. Several board members are uncomfortable with this, but afraid to challenge her directly. Our most significant strategic move came with the installation of security cameras around our property. I mounted them discreetly, but legally, ensuring they covered our front yard, driveway, and portions of the sidewalk. The system included motion detection and cloud storage for footage. The cameras proved their worth almost immediately. Early one morning, they captured Patricia walking onto our property with a measuring tape and camera. She methodically photographed our temporary ramp, measured our grass height with a ruler, and inspected our garbage cans. Most concerningly, she photographed Emma's adaptive sports equipment that had been left briefly on the porch after a physical therapy session. That same day, another violation notice arrived citing unauthorized personal items visible from the street. The security footage provided irrefutable evidence of Patricia's targeted harassment. We added the video and notice to our growing documentation file. Through Robert, we gained access to HOA board meeting minutes that revealed Patricia's selective enforcement patterns. Over the past year, she had denied applications from families she personally disliked, while fast-tracking requests from her social circle. The minutes showed she had rejected 7 modification requests similar to ours, while approving 3 others with comparable visibility from the street. With sufficient evidence compiled, we filed a formal discrimination complaint with the Department of Housing and Urban Development. The extensive documentation validated our claims of disparate treatment and reasonable accommodation denial. Jennifer helped us navigate the complex filing process, ensuring every form was properly completed and supporting evidence properly indexed. HUD complaints can take time, Jennifer cautioned, but filing establishes an official record and demonstrates your commitment to pursuing all available remedies. Our strategy extended beyond legal channels. We researched HOA regulations and discovered that Patricia had exceeded her authority in several instances. The Architectural Review Committee was supposed to include 5 members, but she had been making unilateral decisions without convening the full committee. Board elections were officially scheduled for the following month, creating an opportunity for community governance changes. 3 days after filing our HUD complaint, a courier delivered a certified letter to our home. The envelope bore the letterhead of Blackwell and Associates, attorneys at law. Inside was a formal legal threat from the HOA, drafted by Patricia's brother-in-law's law firm. The letter threatened litigation if we proceeded with any unapproved modifications to our property, specifically mentioning wheelchair ramps. The threatening letter represented a significant escalation, but also a strategic error on Patricia's part. By involving attorneys, she had transformed a neighborhood dispute into a legal matter where federal civil rights laws would take precedence over HOA guidelines. Jennifer confirmed this assessment when we forwarded her the letter. "They have just done you a favor," she explained. "This letter demonstrates that they are doubling down on their discriminatory position even after being informed of your rights under federal law. Their approach is not just wrong, it is legally indefensible." We continued gathering support among neighbors through private conversations. Emma's dignity and resilience throughout the ordeal moved many residents to quiet opposition against Patricia's tactics. Several neighbors offered to testify about the pattern of selective enforcement they had witnessed. Our kitchen table command center expanded with legal resources, community support contacts, and strategic planning documents. What had begun as confusion and hurt had transformed into methodical preparation. Patricia had underestimated not just our determination, but our capacity for strategic response. The final element of our strategy came when Jennifer recommended we request an injunction against the HOA to prevent any retaliatory actions while our complaint proceeded. The court date was set for the following month, with a preliminary hearing to address the HOA's inevitable motion to dismiss our case. As we prepared for this crucial legal confrontation, I realized how far we had come from that first denied application. We had transformed from isolated victims into informed advocates armed with evidence, legal knowledge, and community support. Patricia's discriminatory actions had awakened something powerful in our family, a determination to fight not just for our rights, but for the principle that no family should face discrimination because of a disability. Our strategic response had set the stage for the courthouse confrontation that would change everything. The morning of our court hearing arrived with a weight of anticipation. Emma appeared at breakfast in a conservative navy dress and cardigan, her hair neatly pinned back. She had insisted on attending despite our concerns about the stress it might cause her. "This is about me," she stated firmly. "I need to be there." Sarah helped Emma with her adaptive clothing while I loaded her wheelchair into our van. The courthouse was 30 minutes away in the county seat, an imposing stone building with classical columns and broad steps leading to the entrance. Fortunately, a wheelchair access ramp curved around the side of the building. Ironically, the very accommodation we were fighting for at our own home. We arrived 90 minutes early on Jennifer's advice. "Courtrooms can be intimidating," she had explained. "You will want time to get oriented and comfortable in the space." Our attorney, Mark Goldstein, met us in the main lobby. A specialist in disability and housing law, Mark had reviewed our case pro bono after Jennifer connected us. He projected calm confidence as he guided us through security and toward the elevator. "Remember," he advised quietly, "regardless of what happens in the hallway or courtroom, maintain your composure. The judge will be evaluating not just the legal arguments but the character of the parties involved." The third-floor hallway was lined with wooden benches outside the courtrooms. We found a space that accommodated Emma's wheelchair and settled in to wait. Mark reviewed key points of our case one final time, emphasizing the documentation we had gathered and the clear protections provided by federal law. At 9:30 a.m., a commotion at the end of the hallway drew our attention. Patricia Thompson had arrived, accompanied by her attorney, a silver-haired man in an expensive suit, and 3 HOA board members. She spotted us immediately, her eyes narrowing as she whispered something to her lawyer. Rather than taking a seat at the opposite end of the hallway, Patricia and her entourage positioned themselves directly across from us. The tension in the air thickened as she stared at Emma with barely disguised contempt. "Richard," Patricia's voice carried deliberately down the hallway as she addressed her attorney, "make sure to emphasize how property values decline when aesthetics are compromised. Some people simply do not understand how their special requests impact an entire community." Her attorney nodded, glancing in our direction to ensure we had heard. Emma looked down at her hands, her shoulders tensing slightly. "And these wheelchair theatrics," Patricia continued, her voice even louder. "Coming to court to generate sympathy. Some people will do anything for special treatment." Emma's face remained composed, but I saw the slight tremble of her lower lip. Sarah reached for her hand, squeezing it gently. Mark gave us a warning look, silently reminding us to maintain our composure. Patricia was not finished. "The problem with these accommodations is that once you allow one, everyone wants something. Before you know it, the neighborhood looks like a carnival." She laughed, a sound devoid of humor. "Next they will want flashing lights and horn sounds for the wheelchair." The cruelty of her words hung in the air. Several people in the hallway looked uncomfortable, but no one intervened. Emma's eyes glistened with unshed tears, though her posture remained dignified. I felt Sarah's hand on my arm, restraining me from the confrontation I desperately wanted. "Not here," she whispered. "Not now." At that moment, an elegant older woman in a tailored gray suit approached from the direction of the judge's chambers. She paused near our bench, seemingly absorbed in reviewing documents in her portfolio. Her presence was distinguished yet understated: silver hair in a classic chignon, minimal jewelry, and reading glasses perched on her nose. Patricia, oblivious to the newcomer, continued her performance. "Richard, make sure the judge understands how these people are trying to use disability as a weapon against community standards. It is manipulative and unfair to the rest of us." Emma looked up, meeting the older woman's gaze. Something unspoken passed between them, a moment of recognition perhaps, or simple human connection. The woman's expression remained neutral, but her eyes lingered on Emma with what appeared to be thoughtful consideration. Patricia leaned toward her attorney, whispering something that made him chuckle while staring directly at Emma. The older woman observed this exchange, her eyebrow raising slightly before she continued down the hallway toward the courtroom. "Who was that?" I whispered to Mark. "Not sure," he responded quietly. "Possibly court staff or another attorney. This courthouse handles multiple cases simultaneously." At 9:45 a.m., the bailiff appeared at the courtroom door. "Thompson versus Mitchell, courtroom 3B, all parties please enter." Patricia rose with confident satisfaction, smoothing her designer suit. Her attorney gathered his expensive leather briefcase, and the HOA board members followed like an entourage. She cast one final dismissive glance at Emma before striding toward the courtroom doors. We waited until they had entered before moving ourselves. Mark helped navigate Emma's wheelchair through the heavy wooden doors. The courtroom was smaller than I had imagined, with polished wooden benches, a gallery for observers, and the imposing judge's bench at the front. Patricia and her team had already taken their positions at the plaintiff's table. As we settled at the defendant's table, Patricia's smug expression suggested absolute confidence in her position. She whispered something to her attorney, who nodded with similar assurance. They clearly believed this would be a simple matter of upholding HOA authority against what they saw as an unreasonable accommodation request. The bailiff called the room to attention, and we all rose as the judge entered from a side door. "All rise for the Honorable Judge Eleanor Harrington." The elegant woman from the hallway ascended to the bench, her expression now one of professional neutrality. Patricia's confident smile faltered momentarily as recognition dawned. The judge who would be hearing our case had witnessed her cruel mockery just minutes earlier. The courtroom fell silent as Judge Harrington took her seat and surveyed the parties before her. "You may be seated," she instructed, her voice carrying authority without harshness. "Case number 2025 CV2143, Sunnydale Estates Homeowners Association versus Mitchell. We are here on plaintiff's motion to dismiss the defendant's request for injunctive relief. Let us proceed." As the judge organized her papers, Patricia leaned toward her attorney with an urgent whisper. His reassuring nod suggested he believed the hallway incident would have no bearing on the legal proceedings. They had no idea what was about to unfold. The courtroom proceedings began with formal introductions. "Counsel, please state your appearances for the record," Judge Harrington directed. "Richard Blackwell, representing the plaintiff, Sunnydale Estates Homeowners Association," Patricia's attorney announced confidently. Mark Goldstein, representing the defendants, the Mitchell family, our attorney replied. Judge Harrington nodded, glancing at her notes. I understand the plaintiff has filed a motion to dismiss the defendant's request for injunctive relief. Mr. Blackwell, you may proceed with your arguments. Richard Blackwell rose smoothly, buttoning his expensive suit jacket. Thank you, Your Honor. The Sunnydale Estates Homeowners Association is before the court today seeking dismissal of what we consider an unnecessary and legally unfounded request for injunctive relief. He approached the bench, presenting glossy photographs mounted on foam board. These exhibits demonstrate the architectural cohesion that has made Sunnydale Estates one of the most desirable communities in the county. Property values have increased 17% over the past 5 years, specifically because of strict adherence to aesthetic guidelines. The judge examined the photographs with a neutral expression as Blackwell continued. The HOA has denied the defendant's request for a visible front entrance modification based on established guidelines that all residents agree to upon purchase. Section 4.3 of the HOA Covenant clearly states that exterior modifications require approval based on aesthetic consistency. And what precisely is the modification requested? Judge Harrington asked, though her tone suggested she already knew. A wheelchair ramp, Your Honor, but our objection is not to accommodation itself, but to the visibility and aesthetic impact of the proposed design. Blackwell presented another exhibit, a mock-up of how our ramp might look, deliberately exaggerated to appear obtrusive and inconsistent with the neighborhood style. The defendants have been offered alternatives, including using a rear entrance or designing a less visible solution. The HOA is simply protecting the rights of all residents who invested in the community with certain aesthetic expectations. Blackwell spent several more minutes discussing property values, community standards, and the slippery slope of allowing exceptions to established guidelines. Throughout his presentation, Patricia nodded in vigorous agreement, occasionally writing notes and passing them to her attorney. When Blackwell concluded, Judge Harrington turned to our attorney. Mr. Goldstein, your response. Mark rose with calm assurance. Your Honor, this case is fundamentally about federal law superseding HOA covenants. The Fair Housing Act explicitly prohibits discrimination based on disability, including refusing reasonable modifications necessary for equal use and enjoyment of a dwelling. He presented our carefully documented evidence, the original design plans, the inconsistent enforcement patterns, the comparison photos of similar modifications approved for other residents, and most importantly, the security camera footage showing Patricia conducting targeted inspections of our property. The Mitchells are not asking for special treatment, Mark emphasized. They are asking for equal access to their home for their daughter. The proposed ramp was designed by Mr. Mitchell, a professional architectural engineer, specifically to complement the home's existing aesthetic. The HOA's denial represents a clear case of discrimination prohibited under federal law. Judge Harrington listened attentively, occasionally making notes. When Mark finished, she turned her attention to additional questions. I would like to understand more about the Mitchell daughter's condition and specific needs regarding home access. I felt Emma straighten beside me as attention turned toward her. Before I could respond, Judge Harrington added, Mr. Mitchell, could you please explain your daughter's situation and why this accommodation is necessary? Standing, I described Emma's spinal muscular atrophy diagnosis, her reliance on her wheelchair for mobility, and the daily challenges presented by the current entrance. I explained how the temporary ramp required constant deployment and assistance, undermining Emma's independence and dignity. "Emma is 14 years old, Your Honor," I concluded. "She deserves to enter and exit her own home with the same independence as any other teenager." From the plaintiff's table came an audible scoff. Patricia Thompson had rolled her eyes and whispered something to a board member beside her. When Judge Harrington glanced in her direction, Patricia did not have the grace to appear embarrassed. "Ms. Thompson," the judge said, "do you have something to add to these proceedings?" Patricia straightened, clearly pleased to have the floor. "Your Honor, if I may speak frankly, we have concerns about people exaggerating disabilities for special treatment. It sets a terrible precedent for the community." A collective intake of breath filled the courtroom. Even Patricia's own attorney looked alarmed at her statement. Judge Harrington removed her glasses, fixing Patricia with a penetrating stare. "Ms. Thompson, I was in that hallway just before these proceedings began." Patricia's expression froze, her complexion suddenly paler. "I heard your comments about wheelchair theatrics and your suggestion that the Mitchells are manipulating their daughter's disability for special treatment." The judge's voice remained measured but carried unmistakable authority. "Those remarks raised serious concerns about the motivations behind the HOA's denial of this reasonable accommodation request." The courtroom fell completely silent. Patricia's attorney placed a restraining hand on her arm as she opened her mouth to respond. Judge Harrington was not finished. "Before we proceed further, I should disclose something relevant to these proceedings. I have a 30-year-old son who has used a wheelchair since childhood due to cerebral palsy." The revelation landed like a thunderclap. Patricia's face drained of all remaining color as she realized the full magnitude of her miscalculation. "As both a judge and the parent of a wheelchair user, I have a unique perspective on accessibility issues," Judge Harrington continued. "This does not compromise my impartiality in applying the law. In fact, it enhances my understanding of the federal protections designed to prevent exactly the kind of discrimination alleged in this case." She paused, scanning the courtroom before continuing. "The Fair Housing Act exists precisely because people with disabilities have historically faced barriers to equal housing access based on unfounded concerns about property values and aesthetics. The law is clear that reasonable accommodations must be permitted regardless of HOA covenants or community preferences." Judge Harrington turned to Patricia, whose earlier confidence had entirely evaporated. "Ms. Thompson, your comments in the hallway and again just now suggest that the HOA's denial was not based on legitimate aesthetic considerations, but on discriminatory attitudes toward people with disabilities. Would you care to address that concern?" Patricia looked desperately to her attorney, who rose quickly. "Your Honor, my client misspoke under the stress of litigation. The HOA's position is based solely on covenant enforcement, not any personal attitudes toward disability." The judge's expression made it clear she found this explanation unconvincing. The power dynamic in the courtroom had completely reversed. Patricia Thompson, who had entered so confident in her authority, now appeared small and defensive as the legal ground shifted beneath her feet. Judge Harrington's ruling came with the clarity and force of long-overdue justice. "The court finds that the plaintiff's motion to dismiss is denied. Furthermore, I am granting the defendant's request for injunctive relief." She looked directly at Patricia Thompson as she continued. "The Sunnydale Estates Homeowners Association is hereby ordered to approve the Mitchell's application for a wheelchair ramp within 7 days. The HOA is prohibited from imposing any fines or penalties related to this accommodation." The judge was not finished. "Additionally, I find substantial evidence that the HOA has engaged in a pattern of discriminatory behavior prohibited under the Fair Housing Act. I am referring this matter to the Department of Housing and Urban Development for further investigation of potential civil rights violations. Patricia sat motionless, her face ashen. Her attorney frantically scribbled notes, likely calculating the significant legal exposure his client now faced. Finally, Judge Harrington continued, the court orders the plaintiff to pay the defendant's legal costs associated with this action. Discrimination against persons with disabilities is not just morally wrong but explicitly prohibited under federal law. Homeowners associations do not exist above these protections. As we exited the courtroom, Emma could not contain her smile. "We won," she whispered, the dignified composure she had maintained throughout the proceedings finally giving way to genuine joy. News of the court ruling spread through Sunnydale Estates with remarkable speed. By evening, our phone rang constantly with neighbors offering congratulations and support. The carefully constructed social hierarchy Patricia had established was crumbling. People who had remained silent out of fear now found their voices. An emergency meeting of the HOA board was called 3 days later. Robert texted me updates throughout the proceedings. Patricia tried to justify her actions. "No one is buying it. Vote of no confidence proposed. She is done." The board voted unanimously to remove Patricia Thompson as HOA president, citing conduct unbecoming a community representative and potentially exposing the association to legal liability. Her replacement, ironically, was Robert himself, the quiet board member who had helped us behind the scenes. On Saturday morning, 1 week after the court hearing, I awoke to the sound of vehicles outside our home. Looking through the window, I saw 5 pickup trucks parked along the street. Neighbors were unloading lumber, concrete mix, and tools. Bill Henderson approached our front door with a rolled set of plans. "We thought you might appreciate some help with that ramp," he said, gesturing to the small crowd gathering in our driveway. "Several of us have construction experience. We can have this done by Sunday evening if we work together." Over that weekend, our front yard became the site of an impromptu community building project. More than 20 neighbors participated, bringing food, tools, and materials. Children played together on the lawn while adults measured, cut, and constructed. Emma moved among them in her wheelchair, offering drinks and snacks, her face glowing with acceptance and belonging. The completed ramp exceeded my original design. The neighbors had incorporated additional landscaping elements that made the ramp appear as a natural extension of our home's architecture. As promised, by Sunday evening, Emma rolled up the ramp under her own power for the first time, entering our home through the front door with dignity and independence. In the following weeks, Robert led the HOA board in revising community guidelines to explicitly accommodate accessibility needs. The Department of Housing and Urban Development investigation resulted in mandatory fair housing training for all board members and a substantial fine for the association, money that was ultimately redirected toward community accessibility improvements. Patricia Thompson listed her home for sale 1 month later. On moving day, neighbors notably absent to help, a stark contrast to the community support we had experienced. Emma, watching from our front porch, simply said, "I feel sorry for wherever she goes next." As spring turned to summer, our home became a gathering place for neighborhood events. Emma hosted art workshops for local children on our newly accessible front porch. Sarah organized a community book club that met in our living room. The neighborhood culture transformed from fearful compliance to genuine connection. 6 months after the court hearing, we hosted a neighborhood barbecue in our backyard. Emma navigated confidently among our guests, her artistic talents now recognized and celebrated by the community. As I watched her laughing with friends, I reflected on how our fight for a simple wheelchair ramp had catalyzed a profound transformation, not just for our family, but for the entire neighborhood. The battle had never really been about a ramp. It had been about dignity, equality, and the courage to stand against discrimination. We had found unexpected allies along the way, from quiet board members to sympathetic neighbors to a judge who understood our struggle on a deeply personal level. Most importantly, Emma had learned that her voice mattered and that justice, while sometimes delayed, was worth fighting for. As the sun set over Sunnydale Estates that evening, I watched my daughter surrounded by friends in a community that had learned to see her ability rather than her disability. The path to this moment had been difficult, but in standing up for Emma's rights, we had created something precious. A neighborhood where differences were not just tolerated but valued, where regulations served people rather than constraining them, and where a family could truly call a house their home.